Have you ever thought about writing a sequel to your favorite book series? Well, one Lord of the Rings fan did just that and sparked a copyright lawsuit that rivaled the battles of Middle-earth. Our key players in this legal drama are Demetrius Polychron, a Lord of the Rings fan fiction writer, the Tolkien Estate, and the mighty tech giant Amazon. The tale begins when Polychron, swept up in his love for the epic fantasy, penned his own book, cleverly titled The Fellowship of the King. A fan's homage or a step too far? Well, that's where things get interesting. Polychron wasn't content with just adding his voice to the Middle-earth saga. He decided to sue the Tolkien Estate and Amazon over their spin-off TV series, The Rings of Power, claiming they had infringed on his copyright. Bold move, right? Like a hobbit standing up to a bullrog. But alas, the court dismissed Polychron's case and instead ruled his book as the real copyright infringer. And so our tale takes a turn. As if plucked from the pages of a legal thriller, the courtroom drama unfolded. The gavel fell, and the fate of our protagonist, Demetrius Polychron, was sealed. The Tolkien Estate and Amazon emerged victorious from the legal labyrinth, their pockets heavier by $134,000. Yes, you heard it right. Polychron was ordered to foot the bill for their lawyers' fees. Talk about a plot twist worthy of a Tolkien tale. Now let's delve into the nitty-gritty of this judgment. Polychron, much like Frodo in The Lord of the Rings, found himself burdened with a task of epic proportions. The court ordered him to destroy all physical and electronic copies of his book, The Fellowship of the King. Imagine the bonfire that would create. One does not simply walk into Mordor, and one does not simply destroy a book that was meant to be a 7-part series. But the plot thickens. Polychron was also permanently barred from selling or distributing his book, or any derivative works of J.R.R. Tolkien. Picture this. He's not just banned from the Shire, he's banned from all of Middle-earth. Yet amidst all this legal jargon and courtroom drama, one can't help but find a sliver of humor. I mean, Polychron essentially sued the Tolkien Estate and Amazon for allegedly stealing his idea, only to be sued back for copyright infringement. It's almost like Bilbo's riddle contest with Gollum, only with a lot more paperwork and much less precious things at stake. So the first round went to the Tolkien Estate and Amazon, leaving Polychron with a hefty bill and a pile of books to destroy. But how does this compare to other copyright lawsuits? From Marvin Gaye's family suing Robin Thicke over blurred lines to the infamous Harry Potter lexicon case, copyright lawsuits are as common as a hobbit's second breakfast. Let's take a quick journey through the annals of copyright history. In 2013, Marvin Gaye's family claimed that Robin Thicke's hit Blurred Lines infringed on Gaye's Got to Give It Up. The court agreed, and Thicke's team had to cough up a cool $7.4 million. Then there's the Harry Potter lexicon case of 2008. J.K. Rowling herself took on a fan site that published a Potter-themed encyclopedia, arguing that it infringed on her work. The court sided with Rowling, and the fan site was left with a hefty legal bill. But what about a case that swings the other way? Enter the Wind Done Gone saga from 2001. This parody of Gone with the Wind was initially halted by a court injunction, but the ruling was overturned on appeal, citing the importance of satire in free speech. Now compare these to our Lord of the Rings lawsuit. Polychron, unlike the creators of Blurred Lines or the Potter lexicon, was not just inspired by the original work, but sought to extend it, creating his own sequel. Unlike Wind Done Gone, his work was not a parody. While every case is unique, they all underscore the importance of respecting the originality of authors and creators. So what does this mean for fan fiction writers and creators everywhere? Well, let's think about it. This case could have a chilling effect. It might make creators second-guess their work, fearing they might accidentally step on the toes of big franchises. But it's not all doom and gloom, folks. This could also be seen as a wake-up call to understand copyright laws better. It's about balancing creative freedom with respect for original content. What's clear is that the boundaries of copyright are not a grey area to be trifled with. So, is creativity truly at risk, or is this just a reminder to respect the boundaries of copyright? Drop your thoughts in the comments below, and don't forget to hit the like button if you enjoyed this video. Until next time, this is Hearsay with Eves, signing off.